Hello students, I'm back again at the Desert View Watchtower outside Hagumba Hot Springs on the way to Sentinel State Prison. I'm going to do the video lecture for chapter, what is it? It's one about intellectual property, chapter 11. Okay, this is the video lecture for chapter 11. And there's usually, sometimes there's not a connection between these sort of goofy interstitials and the actual video lecture. I realize that there's a bit of a disconnect. There's an actual connection because they got some piano rolls inside here, and piano rolls are going to show up in the lecture. Here we go, chapter 11. This lecture is primarily about copyright, but we do talk a little bit about trademark. Okay, so what is copyright? That's a great question. Thank you, the student, for asking me that question. You're a very, very good student there. A copyright, I'm reading from the textbook, page 523. A copyright is an exclusive legal right protecting intellectual creations from unauthorized use. U.S. copyright law protects the rights of creators of original works of authorship to use their creations. Okay, that's what it says in the textbook. The goal of copyright, also the goal of patents, okay, they work very similar. We as a society want to encourage people to create new works of art, new sculptures, new dances, new songs, all that good stuff that we love. We want to encourage people to do that. We encourage them to doing by allowing them to monetize their work. So when they create something, they can then sell it. After a certain period of time, the copyright protection is supposed to fade away. Also applies with patents. After a certain period of time, the patent is supposed to fade away. Then the work goes into the public domain. When something goes into the public domain, whether if it's a scientific discovery or a new invention, which might be covered by a patent, or whether it's a new work of art, which would be covered by copyright, once it goes into the public domain, anyone can then freely use it, modify it, and employ it. The goal is that if we can have people creating all this stuff, both artistic and intellectual works, that society will be better. That's the ultimate goal now. Just keep that in mind. The ultimate goal is to encourage people to create things which then we as a society can benefit from once it has gone into the public domain. Now, a trademark is a little bit different, okay? The trademarks are covered in the chapter. I'm only going to talk about that very briefly at the end of this video lecture. A trademark is something that helps a business promote their brand and identity. A trademark, this is from page 549, a trademark is a word, name, symbol, or design used to identify a company's goods and distinguish them from similar products other companies make. Okay, so that is what a trademark is, and that's a Nike swoosh. That's an example of a trademark. And then we have patents. I've already mentioned patents function like copyright, but instead of being for artistic works, it's for some type of scientific creation. Okay, the core principles apply even as the complexity of the law increases. The Supreme Court is getting more and more involved in these copyright cases, and technology moves faster than the law. We have seen this in a number of areas that we discuss in JMS 494, but this dynamic is particularly true when it comes to intellectual property, okay? Technology moves very, very fast. Here's an example of that. 1908. I think this is, what's the name of this court case? Whitesmith. Yeah, let's call this Whitesmith v. Apollo. Okay, court case from 1908. It revolved around the question of whether or not a piano roll violated the copyright for someone else's music. Player piano is a type of piano. There's a picture here. You can buy that on eBay. How much does that cost? Oh, you can buy it now for only $4,000. That's a player piano. You put a roll, imagine something about the size of a paper towel, and the paper has holes cut in it. And as the paper unspools, the holes trigger mechanisms inside the piano, and then the piano will play a song. So the piano roll with holes cut in it, by all logical, any definition, it's a copy of a song. It has copied someone's song. The Supreme Court ruled in 1908 that according to the copyright law as it was written at that time, a piano roll did not violate copyright. So Congress had to rewrite the rules about copyright because of new technology. And this is something that has happened over and over again, where new technology comes out and the laws which were written for a previous era have to struggle to keep up. That's why piano rolls are relevant to chapter 11. What does a copyright protect? Original works of authorship fixed in any tangible medium of expression. As long as it's fixed, it's eligible for copyright protection. Okay. If I write something and don't publish it, it can still be covered by copyright. I don't have to pay money for it. Okay. As soon as it's fixed in a tangible form. Here are the types of works you can read. It's in the lecture notes. Covers a lot of things, including choreography. So if Professor Arsenault developed a TikTok dance to the latest song by Megan Thee Stallion, she's got 2 E's in her name, Megan Thee Stallion. Yeah, that could be eligible for copyright. Now you're curious. You want to see me doing a TikTok dance to Megan Thee Stallion, okay? I like Saweetie better. Is that how you name it? Saweetie? Do you say the A? Anyway, point is that even dancing could be covered by copyright protection. This is like a junk store inside the watchtower, and these are piano rolls. These are piano rolls. Okay, these are piano rolls. Ideas, histories, and facts cannot be covered by copyright. A song or a movie or a film about a real life event could be covered by copyright, but something like the sinking of the Titanic, that actually happened. A car crash, that actually happened. But a song or an artistic expression of that could then be eligible. Design features and clothing, take a look at that section of the textbook. 1972 was a big year. The Supreme Court did some sort of like ruling about copyright, and I think it was 1971. So songs, that's why it kind of varies what kind of copyright protection and what the laws are about music because of when the law was changed. Published and unpublished works. Compilations, yeah, compilations, that's interesting. I'm going to read here for some notes. A compilation of previously created work can be protected even if the individual items themselves are covered by their own copyright. An example might be a book of poetry or something like that. Each individual work retains its own copyright protection. However, the compilation can also, yeah, very interesting. And then individual points of interest in a GPS database and HTML codes underlying websites. Words, phrases created by the U.S. government are not protected. Yeah. Okay. Words, phrases, including advertising slogans, book and movie titles are not protected under U.S. copyright law if they come from, if you were paid by the U.S. government to do it. Now, it's a very complex area here when it comes to work for hire. Okay. There's some questions that the courts have to look at to determine whether or not something was work for hire, or if does the company that paid you get the copyright, or do you get it? Generally, when you're working for some organization, they may ask you to sign something giving them the copyright over that thing. But it is a tricky thing. In the, I think it was the 1980s, don't quote me on that. This was a case, we call it the Betamax case. The real name is something like Sony Universal v something or other. Anyway, let's just call it the Betamax case, okay? In the 1970s, a new technology was invented which made it possible to record television shows, something that had not been possible previously. We call this the Betamax case, although VHS was the technology that actually took over. They both did the same thing. Betamax and VHS allowed people to record TV shows. And, the Hollywood movie studios and television networks, including Disney. Disney was a big person fighting against, Disney did not want video recording. Disney was trying to clamp down on video recording so they could resell you the same movie over and over and over again. Now you need the live action version of the movie that you saw when you were a kid. Disney didn't want people to be able to record things. The courts found that it was okay to record a TV show and play it back for your own personal use. You can't record a TV show and then play it for someone else and charge them money, but you can record something for your own personal use. And I think the courts, I wouldn't say they regret this, but they may have ruled differently had they seen all the technology that was going to come later. People who make films and television shows and music would love to be able to disable any type of home recording technology so that people couldn't copy things. But the precedent was set with this Betamax case that you can record something and use it back for your own personal use. I think that's the caveat. You can only use it for your own personal use. Oh, the funny thing about Disney is that Disney doesn't want people to record things at home, and then Disney quickly figures out, hey, they can sell VHS tapes and now Blu-ray DVDs of their stuff. So now Disney has turned home video into a huge revenue stream. But at the time it came out, they're like, no, 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 we don't want this technology. We don't want this technology. Now, I asked AI to create this image. I said, give me a factory with a smokestack and a bunch of gears making an army of little TVs that are walking around. This is to illustrate the explosion of AI generated media content. At the time of this recording, I'm recording this in June of 2025. We are on the verge of a massive explosion of AI generated content. It might be funny to watch this video in 2 or 3 semesters and to see how severe this explosion has become. But I asked the question, you know, is something created by artificial intelligence, can it get a copyright? And it's another image. I used AI to create it. I said, AI, give me a robot controlling another robot as a puppet. I wanted the original robot to have 4 arms. I thought that would be cool. I wanted the original robot, just to be clear. I wanted a 4-arm marionette, 4-arm puppeteer holding a marionette. Okay. Now, to answer this question, which changes quickly, like whatever I say right now might not even be relevant in a month, 2 months, 3 months. Okay. So I put this question into Google Gemini. It gave me this text. I had an automated voice read the text, which is what I'm going to play right here. This is artificial intelligence answered this question, and then I had another AI tool read it. Oh, the video is Charlie Chaplin from the movie Modern Times getting sucked into a machine. The movie illustrates technology taking over humanity. Okay. Anyway, that's going to do it. It's 2 minutes. Here we go. Okay. So a quick update. I was going to just now, literally just now, I was taking the video that I made, posted on YouTube, putting it into Canvas so I could add the play, pause it, questions and such. Apparently, the original video that I used, which was a clip from the Charlie Chaplin film, Modern Times, that's blocking. I've never had this situation before where that video won't play when I put it into Canvas. Okay, anyway, so the audio that you're going to hear right now is AI answering the question, can something generated by AI get copyright? And it's an AI voice reading the answer to that question. But in terms of video, since I can't use the Charlie Chaplin video that I wanted to use, I'm going to find something else that I have on my computer. I think I have some like POV of someone in a food truck. Anyway, it's kind of funny that I'm running into a copyright issue while I'm making you a video about copyright. All right, here we go. Let's do this.
Can you get a copyright on content that is generated by AI? The general consensus from the US Copyright Office is that content generated solely by AI is not eligible for copyright protection because copyright law requires human authorship. Here's a breakdown of the key points. Human authorship is essential. Copyright law is designed to protect works created by humans. If a work's expressive elements are determined by an AI and not a human, it generally lacks the human authorship required for copyright. Mere prompts are not enough. Simply providing a prompt to an AI and having it generate complex content, like an image, poem, or song, is typically not considered sufficient human creative input to claim copyright over the AI's output. The AI is making the expressive choices. Human modifications and arrangements can be copyrightable. Where a human significantly modifies, arranges, or selects AI-generated material in a creative way, those human contributions may be copyrightable. For example, if you use AI to generate individual images and then creatively arrange them into a comic book with your own text, you might be able to copyright the overall compilation, the text, and your specific arrangement, but not the individual AI-generated images themselves. AI as a tool. Using AI as a tool to assist human creativity does not necessarily prevent copyright protection for the overall work, as long as the human author is still making the expressive choices.
Okay, this is also mentioned in the textbook. I don't know what page off the top of my head. WTF is an NFT. I know what an NFT is. I'm not dumb, you know, non-fungible token, but these things, honestly, I know literally what it is, but like honestly, like WTF? Like, come on, what is this? The law is not even clear. So if you buy an NFT, like if you buy that bored monkey or sleeping monkey, whatever that monkey NFT was, don't. There are other things to invest your money in. I'm just telling you, Professor Arsenault is telling you, this is not where you should be investing your money. Okay. Because when you buy something like this, you may not even get any kind of copyright use, whatever. Stay away from it. Don't do it. Just don't do it. Okay, fair use. Now, if something is covered by copyright, say a song or a TV show or a film or something like that, and I want to use it, I'm allowed to use some of it. That's a general understanding, okay? For educational purposes, like one of these video lectures right here, I could take a little portion, a little bit of a song, a little bit of a movie and play it. I'm claiming educational use. Courts like that. I'm not using the whole movie or the whole song. I'm just using a little bit of it. I'm also not charging money directly. I mean, I know y'all are paying money to be in college. I know college is not free, but it's not like I'm, saying $5 come in, I'm going to show you John Wick or something like that, or Star Wars or something like that. If I'm only using a little bit of it, the court said, well, that's maybe okay. You're using it for educational purposes. And if my economic impact of my use is not going to destroy a revenue stream from the actual copyright holder, that probably is okay as well. But I think fair use and what is fair use and what is permissible with what is not permissible is a fascinating question in this age of remix that we live in. You can claim news reporting as a fair use defense, that I'm a news show, I'm educating people, I had to show a portion of that movie. I've already mentioned nonprofit uses, that's generally okay. If you transform something or change it for use of a parody or something like that, that might be okay as well. This is discussed in the textbook. This film, I don't think this is in the textbook. This is an independent film someone made, Escape from Tomorrow. This was not shot. The Disney park that's in Florida, I get confused between Disneyland and Disney World. If you're from California, you're probably in a cult of Disney and you love Disney. I didn't grow up in California, so I find it to be really weird that people spend an obscene amount of money to stand in line and eat that food, and I just don't get it. But I didn't grow up going to the Disney theme parks. So all of y'all from Southern California who are in the cult of Disney, I won't hold it against you. And okay, the Disney park that's in Florida, whatever the one that is, the one that's in Florida, independent filmmaker shoots a film there entirely inside Disney. It's like a dark science fiction film about a guy having a nervous breakdown. He sneaks in, buys a ticket, doesn't say, I'm making a film, I need permit to make a film, just uses like a home video camera, shoots the whole movie in there. He's claiming fair use, that it's fair use. Disney ultimately decided there was not fair use, but they ultimately decided there's no point in suing the hell out of this guy. We're just going to bring more attention to the film. And it played like the film festival circuit. But suing the film would have maybe made it more famous. No one knows about this film other than people like me. Take a look at the textbook when it talks about Section 512 and DMC safe harbor protections. There's a number of rules that protect internet service providers from infringement claims. If someone puts up something that violates copyright and ISP takes it down, they're not going to be punished. Red flag knowledge means something is so blatantly an extreme violation of a copyright law that the ISP or platform like YouTube ought to have known. Like if I want to post the entirety of the latest season of Andor, YouTube ought to know that's clearly a copyright violation. So in that case, they could get punished. But if I made a video, funny video of me walking around the way I like to do, and in the background, Andor is playing, and I play like, half a clip of it. I didn't like the second season. First season was awesome. Second season didn't do it for me. YouTube might not be in trouble for that, but I might be in trouble for that. Okay, so red flag knowledge is when something's extreme. The argument is the internet service provider, the social media platform, ought to have known. But if Arsenault makes a video where Andor is playing in the background, Arsenault might be in trouble for a copyright violation, but YouTube probably didn't know that was going to happen. And then take a look at this. This is about trademark, and it has to do with disparaging trademark. This group called the Slants. Okay, that's their name, the Slants, a derogatory term for Asians. I didn't mean to offend anyone by saying that. They are an Asian American rock group. They want to call themselves the Slants. Okay, the U.S. government said you cannot use that name because it's disparaging. You cannot have a disparaging name as a trademark. We had the Redskins as a football team for a long time. That's pretty offensive. I'm going to say that's pretty offensive. So just take a look at that court case, be familiar with the gist of it. It makes me think of, there's a term for Cajuns. That's my ethnic background. It is an ethnicity. The slang term is coon ass. Okay, like the ass of a coon ass. It's a very ugly word. It's usually used as an insult. It's considered derogatory. If you're not Cajun and you try and call me that, I'm gonna be offended. I'm not gonna punch you in the face, but I'm gonna be flat out offended. Like, it's not cool. You don't get to use that word. If I'm with some buddies and we're telling jokes about dumb fishermen, you're like, hey, we're gonna tell some dumb coon ass jokes. Hey, that might be okay, but I still don't really like the term. There's a company in southern Louisiana called Coon Ass Seafood, right? And I talked to the man about it during my radio research. I said, some people have issues with the name. I didn't say I find it offensive. I do find it offensive. I didn't say that. I said some people have issues with the name, and the guy immediately says it's not offensive. I was allowed to trademark the name Coon Ass Seafood, so therefore it's not offensive. So I don't know what the outcome is here. I don't even know what my point is here. Just, you should be familiar with the Mattel v. Tam case. That's the kind of thing that might show up on the exam. Okay, that's all I'm saying. That's it for this part of the lecture. Hope I got through the important information, and hope I didn't talk too fast.